Good afternoon. If somebody could get the doors, please, that would be helpful. My name is Tymkovich. I'm the Chief Judge of the 10th Circuit Court of Appeals, headquartered in the Wild Wild West, Denver, Colorado. And it's a pleasure to have a panel like this because it's a bit of the Wild Wild West in labor and employment. It was also interesting to come off a panel discussion on stare decisis, our lunchtime topic, because there's going to be many elements of that in today's discussion. The issue that we're going to discuss is the vast web of federal and state laws protecting employees stands or falls on a single concept. Is there an employment relationship? Payment of overtime, responsibility for employment taxes, union obligations, responsibility for workplace discrimination, workers' compensation. Every employment law obligation depends on the existence of the employment relationship. That may be surprising to some that most employment laws do not define who is an employer or who is an employee. The Fair Labor Standards Act, for example, defines an employee as any person acting directly or indirectly in the interests of an employer in relation to an employee. And an employee is any individual employed as an employee. The National Labor Relations Act also makes us dizzy with circular definitions. An employer is a person acting as an agent of the employer, directly or indirectly, and an employee is any employer, and on and on and on. Well, today's panel is going to try to make some sense of that. As you can see, our three-member panel is only two at this point, and so we've had to juggle things a bit. We're going to start with Professor Richard Epstein of the NYU Law School, a prolific writer and thinker in this area, and he's going to offer some broad topics about the subject matter before we get into the weeds. Our second speaker is Dick Griffin, who has joined us as a former member of the National Labor Relations Board, and in 2012, he was the recess appointment to the NLRB by President Obama. He was then nominated by President Obama and confirmed by the U.S. Senate as general counsel of the board, where he served until October 2017. Our missing speaker is Phil Miscimarra. He's a partner at Morgan & Lewis and has a long history working on employment matters. He's the former chairman of the U.S. National Labor Relations Board, and he currently leads Morgan Lewis's NLRB practice. With that, let's begin. Professor Epstein.
You want me to come up like this? Stand. I have to stand because I can't look into the light. Well, now that I'm going first, I will give a slightly different speech than the one I was intended to, and I've given an immense amount of thought and preparation for this. This is actually a topic of great importance in terms of what's happened, and the judge, I think, actually laid on the line how much turns on so much little. So the first thing I want to do is to pose a kind of a paradox and then ask yourself how it's resolved in one system or another. And the paradox is that the question about the relationships between an independent contractor and an employee, for example, is something which exists at common law as well as existing in circumstances under these variety of statutes. If you look at all of the literature that is accumulated, it turns out that 99% of the literature that accumulates is on the statutory definition, and there seems to be nothing close to the level of angst that exists on this same question when you start to look at it as a common law matter. That doesn't mean that there are no issues at common law, and I'll try to describe what they are in a second, but I think it's important to ask the question, why is it that the problem seems to be relatively easily solved in the private law context and solved only with enormous difficulty when we start to move to the public law context? And so let me go back to the topic which begins. What do we think about the categorization of relationships as a matter of common law, and how does it work? And you could go way back, not only to common law, but to Roman law. And what you typically see in virtually all of these areas is that there are kinds of stark oppositions that are described by the particular doctrines in question. So, for example, in property, we have the difference between a licensee and a lessee. And in employment, we have employee and the employee and the independent contractor. And in other kinds of areas, we have contracts for sale and contracts for hire. And it turns out that these are defined as relatively pure types. And what you then do, very usefully, is to attach various incidents to these things so that when you're trying to solve particular disputes, you will know what's going to happen with respect to unallocated terms. And so you'd have to ask such questions: which way is the risk of loss going to go under a bailment contract or something of the sort? And what happens is, for the most part, when people are organizing their private affairs, what they tend to do is to say with relatively clear and polar illustrations, because it is generally easier to work through something in a standardized form than it is to try and create some blend that's going to sit in the middle. And so what happens is you develop a fairly large body of law dealing with these pure cases, filling in by implication the terms that are needed. And to the extent that you have judges whose sole concern is trying to figure out how you make these more efficient kinds of relationships, there is generally a tendency for these things, when they start to fill in, to be sensible default terms. Once the default terms turn out to be sensible, there is now less and less desire to get rid of them. Sometimes they're going to be codified. And when they're codified, they are basically taking the common law stuff and putting it in a tidy bundle. And so you could see in partnership agreements, for example, all the terms that are not specified in this agreement shall be governed by the California Partnership Act. Basically, you incorporate the defaults into the basic arrangement. Now, that's the basic rule. But what happens is sometimes when people want to engage in various kinds of situations, they would like to innovate. And in order to innovate, it sometimes turns out that you cannot keep these pure cases together, and you have to roll kind of complicated situations. This problem first arose very early on in connection with the forms of action. If you have a contract in which there's a lease with an option to purchase, and you had to bring an executory action, is it a contract of sale or hire? And if you guess the wrong form, you could be out of court. Well, we cured that problem with a single form of action under the federal rules. And then what happens is you start to deal with these mixed cases. You're doing so under a principle of freedom of contract. And if the parties decide that they want to create some kind of an intermediate form, it's perfectly easy for them to do so. They draft something, and they then create whatever relationship they want. And so what will happen is they say, with the exception of A, B, and C, the relationship here is that of an independent contractor, or with the exception of D, E, and F, the relationship here is one of an employment relationship. And the only thing that a court has to do under these circumstances, for the most part, is to figure out what the base is and then to make the particular corrections. And it turns out it doesn't matter how many times you have to do this. You can do it in all these cases. If firm A or line of business A goes in one way, or firm B in line of business B goes another way, there's no need to have a reconciliation of the two positions. It turns out that what you now do is develop a divergence of forms, and for the most part, these then become paradigmatic types in some cases themselves, and the system goes on quite merrily. So within the private kind of framework, the borderline question essentially yields, for the most part, to the general principle of freedom of contract. Now, there is an exception to this, and the exception in many of these cases has to do with externalities. And so one of the common questions that you had about independent contractors and employee is, if you call somebody an employee, you're responsible for the actions that take place outside the scope of the arrangement. And so people would have a tendency to try to call people independent contractors in order to avoid the vicarious liability implications. And then you would have problems similar to those that take place with respect to the kinds of statutes that we're talking about that Judge Tymkovich mentioned. But on the other hand, there's also a relatively simple problem, a solution to that particular problem when you're talking about tort liability. What you want to do is to make sure that the relationships between the two parties are not altered by this externality. And so what you do is you get an insurance policy which covers both the employer and the employee, no matter how they're designated, so that when an outsider is injured, it's not as though you have to sue one or the other. What you do is you have this particular governance relationship in place through the insurance contract. Those monies are free and clear for outsiders. So by using insurance, you separate the internal relationships from the external relationships, and you could organize the contracts exactly the way that you want it to be. And this is generally a very good kind of solution, because insurance means that you could protect contract creditors from tort creditors, and you could assure that the tort creditors have a guaranteed fund to which they're looking. Now, when you come to the situation where you have the National Labor Relations Act, or you have something like the Fair Labor Standards Act and so forth, these options are not open to you. Now, why do I say that? Because one of the things that you can see in many of these contracts, for example, if you look at the Uber contract that it enters to with its various employees, it says, it is understood by virtue of this contract that the employee who drives the car is an independent contractor and not an employee of the Uber Corporation. And then somebody who's a labor lawyer looks at this and sees the Fair Labor Standards Act. And what we now immediately note is that anytime you make a designation of that sort, it has at most presumptive weight in favor of what's done. And if you think that what somebody is trying to do is to get out of a statutory obligation, the presumption in favor of that is going to be enormously thin. And if it's going to be thin, that means it is then going to be something which can be contested by the various sorts of people who are involved in the situation. And at this particular point, the thing that was a virtue in private law, namely the ability to take two extreme forms and then to mix and match them and to combine them to any intermediate position you want, that becomes a fatal vice. And the reason it becomes a vice is that the closer you get to that line between an employee and an independent contractor, the more difficult, the more complicated, the more uncertain it is under these circumstances about which side of the line that you're going to fall on. And whereas in the private law, if there's some kind of a dispute between these two things, it's going to be an incremental dispute, and occasionally it might manifest itself one way or another in a contract. But if you're doing this in a regulatory environment, you're not faced with a gentle slope, you're faced with an absolute cliff, and you're going to find yourself in really desperate situations because coverage is going to turn on something as nebulous and uncertain as the kinds of definitions that we've heard thus far. And so the regulatory scheme, for the most part, is going to be doomed to failure under these circumstances. It's not the function of this, that, or the other rule. What is always going to happen in these cases necessarily is you're not going to be able to find a single litmus test that will solve this problem. You will therefore put forward a list of factors, as you always do, and then you will have to decide on the strength of those factors whether a relationship is or is not on this side of the line or on the other side of the line. Now, at this particular point, there is a real fork in the road that has to take place. And that's the question of whether or not when you're doing these things, you do the factor balancing, however it's accomplished, on a case-by-case basis, or in the alternative, whether you try to do it on a class basis. And this is the way the administrator should think about it, and this is the way that the doctrine starts to work. As the good administrator trying to think about something, you immediately realize that you have, with respect to the question of whether or not an Uber driver is an independent contractor or an employee, or whether or not certain people who work on various kinds of contracts for a software company or one or the other, you have thousands upon thousands of these particular cases, and there's no sane administrator who thinks that what we really want to do under these circumstances is to try to do this thing by a case-by-case adjudication. Being wise, sage, and altogether prudent individuals, what we would like to do is to have ourselves some kind of a per se rule. That becomes the sort of gold standard. But on the other hand, if you look at one of these hapless individuals known as judges who have to sit there, you notice all of a sudden he perks up, right? Me, a hapless individual judge. If you have to do it in that particular way, what happens is, what do? Are they trying to make life easy for the administrator, or are they trying to do justice in the individual case? And so if you just look, for example, at this problem in connection with the Uber drivers, this is the intellectual problem that starts, and the lack of solution in the following way. What happens is, perhaps the single most important element in deciding whether or not somebody is or is not an independent contractor is to ask who has control over the operations of a particular person. And what happens is, in many business circumstances, somebody like Uber really does want to have some degree of control who these particular drivers are. It's worried about the question that if there's some kind of violence or some kind of unreliability or some kind of bad behavior, an individual driver could tarnish the brand and cause them all sorts of harm. And so they want to exert some kind of control. On the other hand, the way in which they attract their employees is to give them options in individual case to turn down an assignment, but they also control that, because if you turn down the assignment, you have to let us know within 15 seconds, and you don't have any longer period of time. And so now what you do is you start looking at all of these cases, and you see that contracts are always different a little bit between two firms, between the same company in two different cities, and so forth. And you're trying to do the control test. And what you've now discovered is it's not a 0-1 kind of operation, that for all sorts of reasons, as a market situation, you want to be able to divide the control. And if control turns out to be the test, and it turns out it's going to be divided, you're going to get very radical differences in opinions. So if you go to California and you're asking this question, all of a sudden these Uber drivers become employees because you have the right to strike them off the rolls if they don't behave in a correct fashion. You go to the Second or the Third Circuit, and then on a very narrow facts and circumstances case, they go exactly in the opposite direction. And they say, we think here that this person turns out to be an independent contractor because of their ability to accept or decline various kinds of situations. And then you start to ask, well, what happens if you move something 1 inch or the other inch? And it seems to me what happens is we will never be able to get a sensible set of resolution so long as we are treating the employee-employer relationship as a matter of public concern. And that the freedom of contract arrangement will actually solve the problem. But what I see happening in these cases is that you will get litigation after litigation, and the only way this thing will settle down is when you get enough of these cases all coming out the same way that it starts to look as a business proposition that it's not worth fighting City Hall on this case. You might as well accept that. But that's not going to be the same result in some courts as it is in other courts, Texas or in California, whatever the difference might be. So essentially, the regulatory framework, when it rejects freedom of contract, creates a system of perpetual disequilibrium, and it's not as though any individual judge or any individual rule is going to be in a position to solve this. Now, what are the sort of consequences for this? Well, in some cases, they can be disastrous. And 2 more minutes or 3 more minutes? I just want to talk about the joint employer problem with respect to unions and Fair Labor Standards Act, and the questions as to whether or not McDonald's is the employer of everybody who works for one of its franchisees. And it turns out the division of authority between the head company and the local company is based largely on efficiency kinds of concerns. You have to standardize the product that is being sold, because otherwise the brand is going to take a hit if somebody chintzes on the kind of quality of work that's being done. On the other hand, McDonald's knows absolutely nothing about the conditions in labor markets locally, and so it doesn't want to have anything to do with setting the wages in terms of employment with respect to people, much of which are going to do place under local law. The standard established rule before the Obama administration started to intervene was to say, this arrangement is working extremely well. We'll just leave it at that particular way, which I thought was the correct answer. And they did it by way of a per se rule. And under the Obama administration, the challenges start to come up on the ad hoc basis. We're going to look at McDonald's franchisees and contracts. 27 of them are bad, 5 of them turn out to be good, and we're going to prosecute one or the other. The danger of having that ad hoc approach as opposed to the per se rule is that essentially what happens is you will destroy the franchising industry if essentially you make a franchisor liable for the unfair labor practices of its franchisees, because at that time it then has to exert enormous control over it. And we know from business experience that the reason they use the franchise model is that putting employees in charge of individual outlets is a much lower productivity arrangement than it is going in the opposite direction. So the plea that I would have in all of these cases is the success of regulation depends exclusively on one proposition. We must have clear and consistent exemptions to know what's going on. We have to keep these joint situations in the labor cases very separate so we never have a joint liability. You have to keep the Uber drivers as independent contractors. You have to make sure that the research assistants at Columbia University, who ironically is very pro-anti-government in that case, that they are not going to be employees, they're going to be students. You have to have the same thing with respect to football players and so forth, same thing with respect to interns. So I hate to say it, but the success of the labor statute is there are cases of clear employees. I would repeal the statutes in all of them, but that's not what's on the table at the moment. But the only way the statute will work is if the exemptions are clear. And if we don't do that, we will basically kill the goose that lays the golden egg, because we can't solve the definitional problem which is built into the statute at the ground level. Thank you.
Thank you.
back on track. Mr. Miscimarra, our next two speakers are going to talk about, in part, the 2015 decision in Browning Ferris, where the NLRB expanded the definition of joint employment. Phil, you want to take us through that?
Sure. Everybody, it's great being here. I recognize many friends in the audience, including NLRB member Bill Emanuel that's in front of us. Also, it's an honor to be here with Judge Tymkovich. Also, I'm here with my friends, Professor Epstein and former NLRB General Counsel Dick Griffin, although I suspect that we have different views when it comes to joint employer status, particularly the NLRB standard governing joint employer status. The title of this session suggests that joint employment involves an unintended and unpredictable employment relationship. And I agree with both of those characterizations, but I'll start out with a little bit of background, and then I'll make 3 points that I think, at least for me, summarize the nature of the expanded joint employer definition that has become the standard, at least under National Labor Relations Board law. And when you talk about laws governing employment, nothing's more fundamental than determining who is an employer and who is an employee. And for many decades, the laws governing employment recognized some situations where two different employer entities might jointly determine the wages and benefits or working conditions for certain individuals. And in this situation, when two entities co-determine essential employment terms, the law would sometimes consider both entities collectively to be a joint employer of the employees. Now, until 2015, the concept of joint employer status was extremely unusual, and it was something that people almost never encountered. And before I was appointed to the National Labor Relations Board in 2013, I had been an attorney practicing labor and employment law in private practice for 30 years, and I never had a client that was deemed to be a joint employer. But in 2015, the National Labor Relations Board decided a case called Browning Ferris Industries, or BFI, and the board substantially expanded joint employer status in 3 different ways. Expansion number 1, in BFI, the board majority held that 2 entities would be joint employers even if they never exercised joint control over one another's employees. And here, the board in BFI held that 2 or more entities could be joint employers merely if vendor contracts or other documents indicated that one party had a reserved potential right to control employment matters for the other party's employees. Expansion number 2, in BFI, the board majority held that this never exercised joint control if it was reserved in contracts or vendor agreements would result in joint employer status based merely on an indirect impact on employment matters. In previous cases, the NLRB had indicated that joint employer status would only result from joint control that directly affected essential employment terms. And then expansion number 3 in BFI involved the board's holding that 2 entities would be joint employers even if their never exercised reserved joint control, which only indirectly affected employment matters, had an impact that was only limited and routine. And in prior cases, the NLRB held that 2 entities would not become joint employers based merely on joint control affecting matters that were limited and routine. So again, in summary, what BFI introduced as an expansion of joint employer status were 3 things. 2 entities could be joint employers even if they never exercised joint control, if the joint control was potentially reserved as potential control in relevant documents. Number 2, the potential never exercised joint control could result in joint employer status, even if it only indirectly affected wages, hours, or other employment terms. And number three, this never exercised potential reserved joint control, which only indirectly affected employment matters, could still result in joint employer status if the potential impact was only limited and routine. Full disclosure, I disagreed with this expanded concept of joint employer status, and I dissented from the board's majority decision in Browning Ferris Industries. And in my BFI dissent, which I jointly authored with former NLRB member Harry Johnson, who is also now one of my current partners, I indicated, and this is a quote, "No bargaining table is big enough to seat all of the entities that will be potential joint employers under the majority's new standard." I also indicated that the expansion in joint employer status exceeded the board's authority under the National Labor Relations Act, which, as many of you know, has important provisions added to the Act in 1947 and 1959, secondary boycott provisions that had the overt purpose and design to prevent different businesses from being enmeshed in one another's labor disputes based merely on their commercial relationships with one another. And at the beginning of the BFI dissent, jointly written by former member Johnson and myself, we started out by saying in our conclusion, the board is not Congress. I'll now proceed to make 3 points that, from my perspective, summarize the problems that have developed in this area based on the expansion of joint employment. And I'll make 3 points. Point number one, the expanded NLRB joint employer standard is truly unpredictable. And here I'll mention one case called Cable News Network. And in the CNN case, Cable News Network had a 20-year history of using 2 vendors who supplied technical personnel to CNN in New York and Washington, D.C. And these technical personnel were camera operators, audio technicians, and engineers. And over the 20-year history, when CNN used these 2 vendors, everybody regarded only the vendors as the employers for these technical personnel, these technical employees. In fact, each vendor was unionized, and the collective bargaining agreements recognized each vendor as the employer. In fact, there were also NLRB proceedings over the 20-year period. And the NLRB, in multiple cases, including union certification proceedings, the NLRB only recognized the vendors as the employer of these technical people. So after 20 years, CNN decided to discontinue its vendor relationships and to bring this technical work in-house. And the NLRB majority decided, over my dissenting opinion, that CNN was actually a joint employer over the technical personnel. And as a joint employer, CNN had a legal obligation to engage in bargaining with the vendors' unions before CNN could decide to discontinue its commercial relationship with the 2 vendors. I dissented in CNN based in part on the 20-year history when everybody, including the National Labor Relations Board, regarded only the vendors as the employers. And I said, this is a quote, "Employer status does not arise as the result of spontaneous combustion." In CNN, in fact, the board evaluated Cable News Network, found that CNN was a joint employer of the vendor employees, even though that had not been recognized over a 20-year period. And the result was improbable. The result was, I believe, a surprise not only to CNN, but to CNN's unions and the technical employees that previously had recognized only the vendors as their employers. This is an outcome that I believe was truly unpredictable. Point number 2, the NLRB and other agencies and courts, in my view, don't have and will never have the resources necessary to adjudicate all of the situations where different clients and customers and vendors and suppliers and franchisors and franchisees are joint employers under the expanded joint employer standard adopted by the NLRB and the Browning-Ferris Industries case. And just to give you an example, again, pointing to CNN, that case involved only 3 entities, CNN and 2 vendors, 2 locations, and the litigation required 82 hearing days before an administrative law judge. It produced a transcript that exceeded 16,000 pages, and there were more than 1,300 exhibits in the case. On appeal, the CNN case was also reversed and remanded based on uncertainty regarding what joint employer standard was even applied by the board in the case. And as many of you may know, there's also been highly publicized joint employer litigation against McDonald's USA and 30 or 31 McDonald's franchisees. And in that case, there has been more than 140 hearing days before an administrative law judge, and the case remains pending. My third point is I have sympathy for the considerations that may have prompted my colleagues, my former colleagues on the NLRB, to expand the concept of joint employment in Browning-Ferris Industries and in a number of other cases. We live in a complicated economy. It would be nice if we could unscramble the economy and eliminate business constraints that prevent conventional employers from being more generous in the wages and benefits and hours worked by their employees. But that type of simple economy has not existed in this country for more than 200 years. And I think you could make a fair case that that type of simple economy has never existed. We live in an economy that has many different types of interrelationships between different businesses. We live in an economy that involves a great deal of specialization. Everybody in this room has benefited, and all of the employees of the United States have benefited from the way that our economy has developed. But it's also important in this complex economy for people to be able to determine for themselves, without assistance from the courts and without assistance from the National Labor Relations Board, who is their employer and who is an employee. And under the current expanded definition of joint employer status, I believe that the outcome in many of these cases is certainly unintended by Congress, and it's also extremely unpredictable. And I hope that we'll end up with greater certainty and more restraint and understandability in this important area of law. Thank you.
Let's hear from Dick Griffin.
So in light of my complete and utter and total disagreement with almost everything said by the 2 predecessors, it's a little difficult for me. It's a little difficult for me to determine how to order my remarks, but I'm going to try and do a little bit of a seriatim review and rebuttal. The first thing is I was very interested to hear Professor Epstein's discussion about how the common law got this right and the administrative agencies and the statutes got it wrong. And part of the reason that that's interesting to me is because the lead case on employee status under the National Labor Relations Act originally was a case that was decided by the Supreme Court involving the Hearst Corporation. And that was a case that involved newspaper, they called them newsies or newsboys. And the question, although they were, for the most part, older people, not boys, and the question was whether or not those folks were employees of the Hearst Corporation or not. And the board, with approval from the Supreme Court, said, using what the Supreme Court called an economic realities test, that they were employees. And you had to look to the purposes of the National Labor Relations Act, what policies it was trying to promote, when you interpreted whether or not these people were employees, because the question of whether or not they were employees, that status, what turned on that status was whether or not they had the protections of the National Labor Relations Act and could engage in certain types of activity without being discharged or disciplined. And in response to that, and Phil is one of the great proponents of this point, and I was a little surprised that he didn't emphasize it in his remarks because I've heard him emphasize it many times before, and I am in complete agreement with him on this point. In response to that, the Congress in 1947, as part of the Taft-Hartley Act, excluded specifically independent contractors from the definition of employee under the National Labor Relations Act, and specifically said the board had to, in doing so, that the board had to apply a common law test. So the test that the board is supposed to be applying is, in fact, the common law test developed over the years and in fact, sort of accumulated in the restatement of agency. And so the fight actually in Browning-Ferris, the case that Phil described, is actually a fight between the majority and the dissent about what you can look at under the common law to make a decision about whether somebody is an employee or not. And the fact is that the restatement of agency talks about the right of control. And implicit in the right of control and explicit in the various aspects of the restatement of agency's discussion of the right of control is there will be times when an entity has control that it has not exercised, but it has a right to exercise, and that right to exercise control under the restatement of agency is sufficient to establish an employment relationship. Before, many years ago, in the earlier days of the board, there were a number of cases where there was a contract between one entity and another entity. And there's no question that the contractor employed the employees, but the other entity that retained the contractor retained within the contract the control to determine wages, hours, and other terms and conditions of employment. And it's that type of right of control, if nonetheless unexercised, that the board majority in Browning-Ferris said is one factor to take into account. So I think there isn't such a large difference between the courts interpreting the factors under the common law and the agency in terms of what the standard is supposed to be. The one thing about the National Labor Relations Act that was the sort of reason for its adoption in the first place was a recognition that employment contracts between a company and an individual employee are not agreements where there is an equivalency of bargaining power on both sides of the equation, where the nature of the relationship can be reordered so nicely as described by Professor Epstein. And in fact, in the preamble to the National Labor Relations Act, it is a specific congressional purpose for its adoption, recognition of the results, the adverse results, that inequality of bargaining power has led to in the national economy of the 1930s. Second point, with respect to the McDonald's litigation, in each of the pieces of litigation that were mentioned, there were a few things that were left out that I think are important for understanding context. And I'll actually get to McDonald's third. Phil mentioned the CNN case, and I'll just make 2 points about the CNN case. CNN was found, including by Phil in his capacity as a board member, to have seriously violated the National Labor Relations Act because when they terminated those vendors, they decided to take the work in-house and specifically determined not to hire any of the people who had been doing work for them for 20 years through the vendors, specifically decided not to hire those people, or a certain number of those people, because if they did, they would have had a successor bargaining obligation with respect to the unions that represented those folks. And so they hatched a scheme whereby they hired a certain number of people, but stayed underneath the 50% number plus one that would make them obligated to bargain with the union that had historically represented these individuals doing this work through the vendors. So much of the litigation in the CNN case involved subpoena enforcement fights over the documents that described the hiring scheme. And that part of the decision is not, I don't think, at issue. There was a violation with respect to CNN. There was an issue, and Phil is quite right, about the joint employment aspect of it, but to attribute the length of the litigation, the number of pages of documents, the length of the hearing, to attribute it to the joint employer issue, I think is frankly not an accurate characterization of the litigation. Second point, with respect, and it should be noted that the CNN decision was a joint employer decision that came before Browning Ferris, that ostensibly applied the prior standard that Phil would like the board to go back to, but it included some of the factors that ultimately ended up in the Browning Ferris decision. And the DC Circuit said, hey, if you're gonna revise the standard, you got to be explicit about it. You can't do it sub silencio. And so that's why the case came back and is in fact in mediation as we speak. The third, or the second case that I'd like to mention is Browning Ferris, and I just want to make one point about Browning Ferris. And that has to do with what the people were actually doing in the case. Browning Ferris runs a waste recycling center. Browning Ferris has quite a few employees of its own who are represented by a union. And Browning Ferris used a temporary agency to supply them with a large number of people whose job was to sort recyclables on a conveyor belt, okay? And these people were essentially permatemps. They were not there for 2 or 3 days. They were there for extended periods of time, working on the Browning Ferris property under the supervision of Browning Ferris, doing Browning Ferris work. A union sought to represent these people and filed a petition with the NLRB for an election to represent these temporary agency employees working at Browning Ferris, and named the temporary agency as an employer, but also named Browning Ferris as a joint employer. What happens when you have an NLRB election, if the union wins, and the employer has an obligation to bargain with the union over wages, hours, terms, and conditions of employment. And the end result of that, if things work out well, is there's a collective bargaining agreement that covers wages, hours, and terms and conditions of employment. And one of the primary things that is grist for the mill of collective bargaining is a disciplinary procedure. So put yourself in the position of the individual employee working on that conveyor belt, sorting the recyclables, and supervised by Browning Ferris supervisors. And assume for purposes of discussion that you screw up and you are told to leave the property, you will not be allowed back on the property by a Browning Ferris supervisor. You think what you did is a relatively minor league thing. Maybe you should be suspended for a day, maybe you should get a warning. You should not be fired from a job that you've had for 14 months or more. If the collective bargaining agreement where you voted for a union to represent you is just with the temporary agency, what can the temporary agency do about that? They can't reinstate you to the line. They can't talk to Browning Ferris to try and work something out to lessen your level of discipline. You need Browning Ferris to be at the table because Browning Ferris is controlling that aspect of your employment. So the concept of joint employer and the Browning Ferris decision is that if there are two entities that share or co-determine your essential terms and conditions of employment, they should both be at the bargaining table. It has been stated that this is too complicated. How are you going to ever negotiate a contract with two people on the other side? Browning Ferris is an incredibly successful large corporation. 1 minute. Oh, well, I got to speed up. So I won't get to my third point, which was to rebut the McDonald's problem. Browning Ferris is a very large, very successful corporation, deals with multiple suppliers, engages in complex business transactions. The notion that once they sit down at the bargaining table with a temporary agency next to them, they can't walk and chew gum at the same time, strikes me as underestimating the sophisticated nature of the Browning Ferris corporate enterprise. And I'll end on that note.
Thank you, Dick. I guess since you went last, that would make you the appellee in my court, which means you would have won below. And so I guess I'll give Phil a little bit of rebuttal. And as part of your rebuttal, could you give us what the current status of the BFI cases and the joint employer issue is before the NLRB?
Yeah, I'd be happy to. And with respect to the points that Dick made, I'll only say 2 or 3 things, but I'll spend 40 minutes saying them. The one thing is, just as a technical point, in cable news network, in the CNN case, there are a number of findings of the board majority that I happen to agree with. I agreed that CNN was a successor employer, and I also agreed that there were some individual hiring decisions that constituted unlawful anti-union discrimination, but I dissented strongly from the NLRB finding that CNN pursued an overall plan or scheme to engage in discriminatory hiring in order to defeat a finding of successorship. And on appeal, one of the judges on the DC Circuit, who is now Justice Kavanaugh, agreed with my dissenting opinion that CNN did not engage in an overall plan to engage in, to pursue discriminatory hiring. He actually quoted my statement in my dissenting opinion in CNN. If CNN was trying to avoid successorship, their overall plan or design was an abject failure because, in fact, a majority of the people that they did hire were former employees of the vendors that were also union represented. But Dick is correct that there are aspects of the CNN case that involved other issues, and I agreed with some of them, but I disagreed strongly with the finding of joint employer status, and I also disagreed strongly with the finding that there was an overall plan or scheme to engage in discriminatory hiring. The one other point that Dick made that I think warrants attention is it's true that CNN involved issues involving arising from alleged joint employer status. There were successorship issues in the case. There are other allegations of anti-union discrimination in hiring. But every case that involves alleged joint employer status will also involve additional alleged violations. A joint employer status standing alone is not unlawful. And part of the problem, from my perspective in these cases, is to throw on top of the substantive allegations in the case extensive proceedings over simply defining who the employer is, I think detracts from the merits of the underlying other claims. And I think that was most evident, for example, in the McDonald's litigation, where the entire case was structured in the order of evidence, placed the question of joint employer liability first, before there was any attention or the introduction of evidence regarding whether any substantive violations of the act even occurred by anybody. And so Yeah, and with respect to the status of Browning Ferris Industries, the case has gone back and forth a little bit between the Court of Appeals for the DC Circuit and the NLRB, but it remains pending in the Court of Appeals for the DC Circuit. And as many of you know, the board in the interim has indicated and has promulgated a notice of proposed rulemaking, a proposed regulation regarding the proper standard to apply in joint employer cases. And that NPRM remains pending. The board's comment period was recently extended, and I think it continues until December 18th, if memory serves me right. So excuse me? 13th. Oh, December 13th. I stand corrected. But so with respect to joint employer status, rulemaking is currently underway at the NLRB, but Browning Ferris Industries and the appropriateness of the board's decision in BFI remains pending in the Court of Appeals for the DC Circuit.
Epstein, you played no role in the Browning Ferris litigation, but is there some consistency with the Browning Ferris approach in your common law?
Oh, yes, let me
motion?
comment on, I have two things to comment on. One is that, first of all, I think Dick is 100% wrong to say that what they did was to simply incorporate common law tests in the statute. Because the common law had a freedom of contract override, which would allow people to figure out these intermediate cases in whichever way they wanted to do so, except to the extent that there were third-party issues for which the insurance was the coverage, and you don't have that degree of flexibility. And so what the Supreme Court does is it decides to call these newsboys employees, and then you get a statutory override which is imperfect and creates just another level of situation. None of this would happen in the contractual world. And so the point that I wanted to make, and I will continue to make, is that if you try to use these tests to override voluntary arrangements between the parties, it will always be a failure. The second point I want to make is there is no stupider statute, no more ignorant set of preambles than you find in the National Labor Relations Act of 1937. And the thought that a serious academic discussion should take as a given that there is inequality of bargaining power between unions and workers without any demonstration of that fact strikes me as one of the fatal conceits of the New Deal. If you look at wage patterns before then, they are quite consistent. What happens is they move up consistently with productivity because employers, wholly without the benefit of a union, bid up wages. If you start talking about inequality of bargaining power as a serious conception, you can never come up with a contractual equilibrium because it means every time it turns out that the employer says, I want this, he said, well, I've got inequality of bargaining power. You can't get that, and you'll bid the wages down to zero. That doesn't happen. What happens is these employers need these workers as much as these workers need their employment. And in terms of wage increases in the period between, say, 1870 and 1935, it's the greatest advance in the condition of the working man in the United States that we've ever seen. And it's only the genius of the New Deal that basically takes a competitive market, treats it as though it's a form of oppression, announces that it's a failure, and then puts into place a system which is so rigid. And the great problem that one sees with this is evident, even if we do, as I think we ought to do, take the traditional doctrines of success or liability. What labor markets need is flexibility. What the successor document does is it means that you always have to have a bilateral monopoly negotiation to get yourself out of a losing deal. There is no more systematic set of inefficiencies than are associated with the National Labor Relations Act. And so the question to Dick quite simply is, we're trying to figure out this as a social allocative mechanism. Given the amount of money that we spend on this stuff, what improvement in output do we create by putting into place a system of rigidities? We lose two ways under the National Labor Relations Act. It costs a fortune to administer a statute which always comes out with the wrong result. And I fail to see why it is because some guys put together a preamble, all labor guys in 1935, that somehow or other everything we know about industrial organization should yield to a set of congressional findings that is simply unmatched for their ignorance on the topic on which they address.
And before I open,
Could I respond to that?
before I open, I'll open up to the audience in a minute, but I'll let Dick get the last word.
Not to put too fine a point on it, but this country teetered on the brink in the middle of the 1930s. There was mass unemployment. There were, in order to come up with the aforementioned language of the preamble, Senator La Follette held a series of hearings about the bases for the the economic situation in the country that lasted over an extended period of time and is frankly fairly unmatched in congressional history. And I just couldn't disagree with you more. And if I may finish, I didn't interrupt you. The notion that the labor market is efficient is completely belied, and that wages rise with productivity is completely belied by the last 30 years of experience, where you have very substantial increases of productivity not matched in the least by wage increases. And the statistics on that, the empirical evidence on that is fairly irrefutable.
Let me open up. All right. Well, I like the adversary system here. So let's go ahead and open it up to the audience. We have two mics going around. Any questions?
As a non-employment and labor relations lawyer, I do a lot of commercial real estate and construction. I can't find a scenario, I was taking notes, in which it would be possible to fully protect one of my developer clients or myself in a development from being held to be a joint employer under some of these decisions. But from an historical standpoint, to address both of you, the lessons of history are the oppressed eventually become the oppressors, and we have seen that, I think, go both ways in the United States. From, if you take everything into account, employers and then the unions, in the end, there's a lot of balance. But I also have to say that I agree with Professor Epstein.
Repeat the question. I didn't quite get it.
I think she said she agreed with you.
Oh!
Take yes for an answer.
I always do. I'll be silent.
See, there's a couple back there.
Thank you. Good afternoon. Thanks for coming. I'm actually an employment lawyer, one of the many Federalist Society members who actually represents Federalist Society. But anyways, I have a question regarding the joint employment. This is specifically for Professor Epstein, and this is a hypothetical dealing with one of my cases currently pending before an agency. So you have an agency official who touches the breast of an employee who's hired by a defense contractor. How does that change the analysis as far as, I'm not sure I understood the insurance analysis, but how does that inform you as far as whether or not that should be considered a joint employment relationship when you've got a private contractor providing an employee to work directly for the federal government agency? She reports the bad behavior of the government person to her boss and then gets fired.
Well, I mean, I'm not quite sure what the particulars are, but let me give a general answer, which I think echoes what Phil said earlier on. If you look at a case like Browning Ferris, and it turns out you take the pre-Obama board redefinitions of it, and it turns out under the statute it's a joint employment relationship, that's fine. It seems to me that what one ought not to do is to expand the definitions by using all of these indirect tests and hypothetical control type cases to situations where historically it was never implied. And I think it's extremely important to understand that if you have a set of statutory definitions that are so utterly porous, what you never want to do is to change by administrative fiat those definitions to something which has never been tested and implied. I think that's also true with respect to many constitutional questions. Accumulated practice gets a very heavy situation in its favor. Certainly the franchising industry grew mightily under these particular rules. So I would say I don't comment on individual cases. What I do comment on very strongly is the notion that an administrative agency, which is largely ignorant of the multiple facts on the ground, would change a rule that has worked to something which has never been tried or explicated. I regard that even within the administrative state as a form of recklessness. And on this particular point, the older views on administrative law were always of the effect that if there's an early practice by those who knew and were familiar with the statute, that ought to prepare against a sudden change of policy later on. That was a 19th-century view consistently exercised. That is, I think, the correct way to look at these questions.
Dick?
I agree very strongly with that proposition because the test that the board moved to in BFI was actually a reformulation of the test that was applied without full articulation for the basis from 1935 to 1984. And then in 1984, in a series of cases that I think Phil would agree form the basis for the current doctrine that BFI reacted against, the two main cases, TLI and Laerco, the board started to say that a number of factors that it had looked at before were insufficient. What you needed to have was a direct, immediate, substantial involvement for the putative joint employer to be held to be the joint employer. Now, I may be overstating a little bit that, we filed a brief before the board in BFI arguing that they should return to what we articulated as the traditional test, that 1935 to 84 test. There was not a lot of articulation in those cases, I'm prepared to concede, but they did look at these other factors that the board did expand back in that direction in BFI.
Phil, there was actually a subsequent case, Highbrands, that was then vacated. Are there other cases that might challenge the Browning-Ferris logic before the board? And
I'm no longer a member of the National Labor Relations Board or chairman, but I understand that there are, so I don't know what's currently pending before the agency, but I believe there are other joint employer cases that have been brought before the agency and happen to be pending at the level of the NLRB. I'd also say that I don't agree, although Dick suggested I would, with his characterization of the law preceding Browning-Ferris Industries. But I would note that in the 1950s, the Supreme Court held in the Denver building trades case that a construction industry general contractor is not the employer of its subcontractors' employees, even though in the construction industry, and we're talking about real estate, the real estate industry from one of the questioners, even though a construction industry general contractor obviously exercises control over virtually everything that goes on at a construction site. So, some of the lines that exist in this area aren't the result of what I think is a good idea or what others think is a good idea. I mean, there are very strong benchmarks and underpinnings of the law that have been created not only by Congress but by the Supreme Court. And that's one example where I think it's clear that long-standing existing law is incompatible with where the BFI decision went when it was decided by the board majority in 2015.
And I'd just like to say one thing, because I didn't really get a chance to address this franchisor-franchisee issue, and I'll be brief about it. The basis for franchising is essentially the ability to license your trademark. Historically, it was unlawful to license your trademark. That got changed, and that means that you can now license the trademark. You have a duty, though, to police the brand and to make sure that the trademark is not adulterated. In the 1970s, during the Ford administration, the general counsel of the board, John Irving, brought a series of cases against franchise industry, franchisors, franchisees, alleging sort of an enterprise liability theory. And coming out of those cases, including single employer, joint employer, there are a bunch of stuff thrown into those cases. But what came out of those cases was, if what the franchisor is doing is policing the brand, pursuant to its legal obligation to do so, that engagement with the franchisee is not a basis for holding the franchisor to be a joint employer. And in the McDonald's case, the general counsel's complaint and theory of the case acknowledges that and agrees that that type of activity is insufficient to convey joint employer status. It's going beyond that in your involvement in the operations of the franchisee that is the basis for the McDonald's case, and we could spend a lot of time, and I'll stop there.
Yeah. Yeah, quickly.
Yeah, I mean, policing the brand is a deceptive term. You also have to police the quality of the work that comes out underneath the brand, and that means you have to have some degree of control of the way in which the product is presented and prepared and so forth. So every single franchisee in a non-union situation where there's no risk of a union has much more comprehensive control than that. And it seems to me that what you really want to do is to take your benchmark not off of this artificially narrow definition of what a franchisor does, but off of the standard practices of contracting that take place when there's no union issue involved, and the McDonald's contracts don't differ very much from those.
I think there was another question over here.
Yes, Mr. Griffin, you referred to the hiring practices of C&M with respect to vendor employees to keep those hires down to not hit a certain statutory level to thereby impose successor coverage. You referred to that as a scheme. Why would trying to avoid a statutory number to implicate the application of the statute, why would that be a scheme?
Because if and let's just talk about it in the abstract, if the reason you make a hiring decision is based on someone's support for or non-support for a labor organization, that's a violation of the National Labor Relations Act. And if you are seeking to, if you make a decision not to hire Sam, not based on Sam's merits, but because if you hire Sam, you will have an obligation to bargain and you think Sam supports the union, that's what I'm talking about.
That is an unfair labor practice, and that's the problem. My basic view is yellow dog contracts, which require you to demand unquestioned loyalty from all employees, are the essential free market organization, and that's why the National Labor Relations Act is wrong, because what it makes sure that every employee now has dual loyalties.
So do we have a question on this side of the room? There it goes.
I told him to do it.
Get a microphone.
Will you stand behind this gentleman right here and then wave
It's
it?
coming.
It's coming. It's coming.
All right. All right, thank you.
There we go.
Given the disputed jurisprudence in this area, I'd like the panel's thoughts on the desirability and the feasibility of rulemaking to address this problem from a prospective and hopeful, thoughtful conclusion format.
Phil, you want to start with that?
Yeah, well, the board obviously has the authority under the National Labor Relations Act that's expressed to engage in rulemaking. In fact, in 2014, I participated in rulemaking that produced regulations relating to the NLRB's election procedures that ran 735 pages. I'm told the best part of that regulation started on page 494, which is where the dissenting views of former member Miscimarra and Johnson started. But the board is engaged in rulemaking rarely, but it's, I think, clearly appropriate, and I think that it's clearly appropriate for the board if it chooses to engage in rulemaking, which is commenced, regarding the proper joint employer standard.
Dick?
As you know, Roger, because you were involved in the healthcare bargaining unit rulemaking, the board has on a couple of occasions abjured its usual establishment of rules through case-by-case adjudication and has chosen to engage in rulemaking. And I agree with Phil that there's there's statutory authority to do it. Whether or not this particular issue is a good one for rulemaking, I think I disagree with Phil. I think there's a good argument that the prior law, both the stuff I referred to pre-1984 and the 1984 up to BFI law, really the basis for the board's position was not very thoroughly articulated. I think it was very thoroughly, whether you agree with it or not, the Browning-Ferris decision on both sides, the majority and the dissent, articulates very thoroughly the basis for why the majority believes the rule it adopted was within the scope of the common law and why the dissent finds it not appropriate. And that's really the first full articulation of the basis in the history of the board on the subject, and it's pending in the DC Circuit. So my view would be, particularly because on questions of common law, the board is not entitled to really much deference. It's only entitled to, if they're equivalent views, defer to otherwise equivalent views. So my own feeling is that the board should wait and see what the DC Circuit thinks about BFI rather than embark on.
Has there been an increase in litigation post-BFI?
No, there are very few cases that allege joint employer post-BFI, and there's no indication that there are more joint employer allegations post-BFI than pre.
That's the most happy thing I've heard. May I make a comment on the general point? I think that, generally speaking, in a context like this, you do not want to use rulemaking because you will never come up with a rule. What will happen is you will have rulemaking, as long as you said, and the rule will be, here are the 16 factors you have to take into account in order to figure out whether or not somebody is, under this circumstances, A. And there'll be choice: employer, independent contractor, employee, student, employee, intern, and so forth, under this statute or any other. So I don't see the gain in that because it's going to take a long period of time. I would rather, therefore, that the board take its position and do it that way. But again, let me be very clear. This is the question of second and third best. The first best is I can stipulate by contract in one paragraph, you will be my employee, you will be my independent contractor, and we don't need to go through any of this stuff. And it's the reason you have the problem of choosing between 2 and 3 is we completely reject the freedom of contract approach for reasons that the Lafayette Commission, I did not think, understood. And when you're trying to figure out the depression, it wasn't labor markets that did it. It was monetary markets and foreign trade. And you can't cure those two defects by messing up the labor rules. And so this whole thing has been a completely misguided enterprise from the beginning.
There's a question
Judge,
over here.
If I may just make two quick points and then go to the question. One, the absence of a flood of cases in litigation regarding joint employer status, from my perspective, is indicative of the problem. It's not indicative of the lack of a problem, because we have articulated these very broad, expansive standards now that suggest many companies that have business relationships with one another are thereby joint employers. And to the extent that there are only very few isolated cases that litigate that status, that means this entire area is going to be populated with arbitrary questions about who gets their ticket punched and who doesn't. Most parties are trying to comply with the law, and it's only feasible to expect that parties can comply with the law if they understand the standards without the assistance of litigation or cases that go to the NLRB. So the absence of a lot of cases in this area, to me, with an expansive standard is indicative of a problem, not the absence of a problem. The only other thing is I disagree with Richard's description of the rulemaking because, number one, we don't know where the rule is likely to end up. And number two, I think unlike Browning-Ferris Industries, which adjudicated a particular situation that Dick described in his own comments, the proposed rule that is promulgated not only articulated a standard that resembled the state of the law prior to the 2015 BFI case, it also included 11 different examples, and a final rule might even include more examples. And one of the benefits of rulemaking is you can end up having an agency address a range of different situations that in many respects can be much quicker and much more expansive than what an agency like the board can do in any particular case.
Let's get a question.
Hi, Pepper Crutcher from Mississippi. Among other things, for about 40 years, I've been negotiating labor contracts. And it's very common that the union and the employer get together and agree that these permatemps working here in our organization, they are not the employer's employees, and there are good, sensible reasons from the union's point of view why they would agree to that. Is that agreement between the union and the employer, although it binds people not represented by the union, is that deserving of deference from the National Labor Relations Board? And if it is, why is it?
Well, it did not receive deference in the CNN case because there was a collective bargaining history that spanned 2 decades where the employer, the only employer named in the collective bargaining agreements, each of them were the respective vendors. And with respect to what the board would do if they had a similar situation prospectively, that would be up to the current members of the NLRB. But I thought that the parties' practice and who the parties historically regarded as the employer was a very important consideration, at least from my perspective in the CNN case.
Yeah, and I would agree with that. And I think for the most part, when people are excluded pursuant to agreement, that's something that historically in most situations has been honored. The CNN case is fairly, is different in that regard. But I don't think as a general matter, people ought to be, concerned about the nature of those type of arrangements. I would say just for 1 second, the board actually of the employment statutes, the definition of the employment relationship under the National Labor Relations Act is the narrowest. The Fair Labor Standards Act, where the definition of employee is suffer or permit to work, has been held by the Supreme Court to have a broader than common law definition. And so when you're thinking from a defensive standpoint with respect to how employers should arrange their relationships, and you're looking at a statute that has a private right of action, that has attorney's fees for the prevailing party under the Fair Labor Standards Act, and a broader definition versus the National Labor Relations Act, where there's no independent investigatory authority in the agency, there is no private right of action, and you have the narrower common law definition. I think from the employer's standpoint, what they want to be more concerned with, just my own view, is that the FLSA potential liability is a more likely legal question to arise than the NLRA issue.
It's complicated because in areas where unionization is possible, it is generally guarded with greater dread. But in those cases where it's not possible, particularly with respect to the overtime provisions, which do not have a minimum wage associated with them, the liabilities are indeed enormous under these circumstances. And yes, there are private rights of action, and indeed many of the cases having to do with Uber and with these various kinds of interns are all FLSA actions, they're not otherwise. Again, my view is I'm adamantly opposed to all of these statutes, but I agree with Dick that the differences that he makes are really relevant. I don't think it's a uniform rule, but I do think it's presumptively one that if you looked at all of America's employees, the FLSA is probably more dangerous, particularly since its definitions are broader, and joint control or joint status in laboratories and so forth is very, very common.
Yeah, we have time for a couple more.
Professor Epstein, you emphasized the importance of the uniformity of freedom, but I assume that the constituents in California have different preferences with respect to their labor laws from the constituents in Texas, for example. Shouldn't companies like Uber be expected to conform their businesses and their practices to the preferences reflected by those very different citizenries?
Well, this is not an argument about the substance. This is an argument about federalism. And I think the answer is yes. If there are variations in state law where the federal government doesn't apply, any national corporation has to be able to yield to what is going on locally. But the point I was arguing with respect to the California case is that they got the wrong definition on the merits, and there was nothing about the situation in California which justified a different rule from the one that you start to see elsewhere. The cost, of course, if California is an outlier but a very large state, now it's going to be that much more difficult to run one of these companies if you have to worry about the ways in which things are going. But yes, I do agree with federalism, but let me be very clear. In the morning sessions and some of these sessions, you hear all these wonderful encomiums with respect to federalism. I regard those as essentially somewhat optimistic. To me, the real problem is you could get abuses at the federal level, and you could also get abuses at the state level. And a system of federalism which allows each state to go its own way creates a problem that you haven't alluded to, but which I'll briefly mention, which is mainly, suppose 60% of the people in the state think one way and 40% of the people think the other way. If you just have strict majoritarianism under there, there's going to be a real danger of expropriation. And the basic scheme of the Civil Rights Amendments, all of which took place, 1865 to 1870, the whole purpose of those things, ironically, was not to tell the federal government that it could regulate in areas reserved to the state, but it was to put a huge filter so as to strike down many of these things under privileges and immunities, due process, or equal protection, so that there's a kind of a federal constitutional veto right. And that's a very different arrangement than the one that's commonly understood today.
Okay, I think we have time for one more question.
There must be somebody.
Come on, somebody's got to finish this up for us.
Why don't we have 1 minute from everyone?
We'll do a 1 minute rebuttal.
And I'll just, thank you very much. I'll just make two quick points that haven't been addressed, and they're both related. One is, part of this session's topic talks about unintended consequences. And I think many companies that have not only tried to do the right thing for their employees, they have received pressure, and many of them have aspired to do things and use whatever purchasing power they have to further objectives associated with social accountability, corporate responsibility, and this push to suggest that any type of potential control that a major business or a major employer might exercise on somebody else's employees converts that larger corporate entity into a joint employer, really subverts many of the objectives that I think people have been trying to advance when talking about significant businesses and companies over time. And even in the collectively bargained sphere, there are the Supreme Court and other courts have recognized the validity of union standards clauses involving subcontracting, where employers are permitted to engage in subcontracting to other entities that pay their employees the same standards that are applicable to the parent employer. And those are additional consequences, I think, that are ill-advised and that are associated with where the law has gone in this area.
Dick?
Yeah, I would say the argument that Phil just made is what I characterize as the bad Samaritan argument. That is, you want to be involved, you want good things to happen, but if you get involved and good things don't happen, you don't want to be responsible for the consequences. And that's typically the argument that's made in some of these instances where you have large corporate actors who want to appear from a public relations standpoint as though they're trying to do the right thing, but if they don't make sure that the result occurs and somebody says to them, you need to get involved and make sure that this good thing that you're professing out in public, you're promoting, needs to happen, they say, oh no, it's not our responsibility, we don't want to have anything to do with it. And so my own view is if you're going to take the thing on and you think it's a good idea, you ought to see it through and make sure it happens. In the legal tradition of the Good Samaritan, you don't have a responsibility, but when you take it on, you have a responsibility to see that the appropriate standard of care is exercised, period.
Well, the basic position that I would want to start with is that competitive markets will outperform any unionized markets. One cannot make that argument in the abstract with respect to a national labor relations statute, which starts from the opposite premise. So what you have to do is to start thinking about more limited arguments that will address some of these issues. And I disagree with Dick that when you start talking about these cases of divided control by McDonald's and so forth, what all they're trying to do is to keep the control on the one hand and to get their hands clean on the other hand when it turns out that something works. I think that would be true if, in fact, this was all a sham arrangement. But they've discovered through bitter experience that they cannot possibly try to run, given what was said later, the local conditions in labor law and so forth, and zoning law and all the other stuff from the center. So if there's a bona fide separation with respect to the activities in question, and you have a labor statute, it seems to me that the labor statute should follow the business separation, and you could try to unionize the subunits, but you can't try to unionize McDonald's. And in fact, the bargaining implications for that would be there are 3,000 McDonald's factories or outlets, or 10,000, 20,000 around the country. If they're a joint employer with all of their particular franchisees, I have no idea of what kind of negotiations they're going to be entered into. It is important to have employers who are close to the ground. It is important to have employers who have relatively homogeneous relationships. It's important to have a situation where there's only one possibility for unionization, not 2, 3, 4, or 5. And what the new rules on the joint employer situation do was to change that. And it cannot be that these rules are just going back to the earlier situation, because I'm not aware of any case, and McDonald's has been around for a very long time, where it has ever been exposed to a threat of joint employer situations in 1962. So that would be my last word.
Well, who knew that the joint employer could be that interesting and lively? Please help join me in thanking the panel.